Okay, so let's make a start.
Yeah, I'll just begin by reading out a short statement, if that's okay.
Yeah, absolutely.
The hearing on this matter is being held by way of teleconference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on Justice Wayne Martin's instructions. This ex parte hearing today is in the matter CFI-031-2020 before Justice Wayne Martin. The claimant is represented by Clyde & Co. Lead counsel is Rupert Reed, QC, assisted by Gregor Hogan.
Good. Thank you very much. Mr. Reed.
Well, Lord, good morning. I can't see you. I don't know whether I'm supposed to be seeing you, but I don't have a picture.
No, I'm afraid we're doing this only by telephone, but you should be relieved because I'm not terribly suitably dressed, I have to confess, Mr. Reed.
Me neither. I didn't have a suit when I was locked down, so... my Lord, this is an urgent without notice application for a freezing injunction. I understand you've had the application papers and documentation.
I haven't, Mr. Reed. You can address me on the assumption that I've read all the papers, including the skeleton argument, the application, the affidavit, and the draft order. So if that's short,
that's very helpful. There are just a couple of points of housekeeping I should raise before I go on. Firstly, in respect of the affidavit, although it's dated the 9th, it was actually, in fact, affirmed on the 10th at 1 a.m. in the morning. Right. I don't think that should affect its validity in any way. I should also point out that it was affirmed by video call, given the circumstances. As your Lordship may be aware, Dubai is in a very strict lockdown at the moment, so that was the only means practically by which that could be achieved. And I should add too that as a matter of practicality, the only person who could affirm it was another partner within the firm of Clyde & Co., she being Rebecca Ford, who I understand to be the employment law partner in Clyde & Co., and a partner who has nothing to do, as I understand it, with this case. So again,
thank you very much for that. And obviously you tender that affidavit and rely upon its contents?
We do, my Lord, yes.
Yes, well, I'll take that as received in evidence and read.
I'm grateful. Your Lordship will be aware of the provisions in the RDC that provide for freezing injunctions and disclosure orders. Just for the record, they are RDC 25.1, subparagraph 6 and 7. There's a statutory underpinning in the court law and the law of damages and remedies, which I don't think we need to look at. I think that we can assume that this court has a jurisdiction to make a worldwide freezing order and an associated information disclosure order. By way of background, your Lordship will have seen from the skeleton underlying documents, essentially there are two relevant debtor companies, that's to say NMC Healthcare and NMC Trading. The first is a Dubai entity, the second an Abu Dhabi entity. I think in paragraph 7 of our skeleton is a corporate chart which sets out how those two relate to each other. They do in effect sit under a UK holding company, that's NMC Health PLC, which is a public company until recently a FTSE 100 company. The group has been under the effective control of Dr. Shetty, who is the respondent to this application and against whom the freezing order is sought. There are two further significant shareholders, Mr. Saeed Mohammed Al-Bouti and Mr. Khalifa Bouti. I'll refer to them collectively as the Boutis, if I need to, and without any disrespect. The group, as your Lordship may be aware, in general, has been buffeted in recent days by financial scandal. There has been an independent board committee that has been investigating these matters with the assistance of independent financial and legal advisors, specifically PwC and Allen and Overy. That investigation has resulted in a series of financial announcements, and I'm grateful for the indication that your Lordship's had the opportunity to read those announcements by the independent committee of the board with the assistance of those advisors. And what has emerged in the management of the group are a number of very disturbing practices. Firstly, the pledging of shares owned by the key shareholders, and indeed the enforcement of security against those shares without those pledges and those share transfers being disclosed to the company, as is required under the listing arrangements for public companies. Secondly, related party transactions, that's to say transactions secured for the benefit of third parties, related third parties, secured using company assets. And thirdly, the concealment of balance sheet debts. So the company has incurred massive amounts of debt that have not been on the balance sheet and therefore being concealed not only from the board but from auditors. And indeed, even the independent committee of the listed company, the topco, if you like, have disclosed the possibility that there has been serious fraud perpetrated in respect of the management of this group. And so we say that this is a clear case, given the proximity of Dr. Shetty to the management of this company, for an assumption that he has been engaged in highly discreditable misconduct, which justifies, in circumstances where he has failed to pay as personal guarantor, the freezing of his assets worldwide. You will have seen in the papers, my lord, a net worth certificate completed by Dr. Shetty. It may be worth turning that up. It's within the
yes.
It's in the exhibit.
Yes,
so
next to the draft order. Yeah.
Exactly. Well, it's next to the draft order. It's also at page 22 of the exhibit to the affidavit. I'll just. And you'll see immediately that it is certified by a firm of chartered accountants and certifies him as having, as of the 13th of June 2018, assets of 8.045 million dirhams, so something over around $2 million US dollars. In terms of the nature of those assets, it appears a very substantial amount in bank balances within the UAE, the investments in the businesses, investments in properties, and one sees, and also consolidated cash in banks as reported by the UAE Central Bank, again, June 2018.
Well, the lion's share, just stopping you there, Mr. Reid, the lion's share is in quoted shares, which presumably is in the two groups that are presently troubled. So presumably a big chunk of that value would not now exist. Would that be a reasonable inference?
I think that is a reasonable inference. I imagine the value has dropped very significantly. I can't say with any certainty what the value of those shares currently is. They've been suspended from trading, so it's not clear that there will be an open market value or a traded value for those quoted shares. I imagine too much of the value of the unquoted shares will similarly have been affected. It's been clearly suggested that given the revelations in respect of Dr. Shetty, anything in which he's involved is clearly contaminated and infected by the sense that of irregularity, in the sense that there may be significant financial misreporting, such that the value on any basis is hard to estimate. There is also clearly.
Sorry, just putting the shares to one side, the properties are said to have a value of 664 million dirham, which would be about 150 million US, one imagines. Now, again, that was a valuation as at, I think, July 2018. One would think that the virus would have had an impact upon the value of those properties, but there's still a very substantial amount of value in those properties, isn't there? I'm just thinking the reason it's relevant, the reason I'm asking these questions is to try and establish the relativity between the amount to which you're seeking security and the assets that might presently be available to Dr. Shetty.
Well, your Lordship anticipates precisely the point that we are seeking to freeze just over $8 million US, and the property assets alone in Dubai, Abu Dhabi, and Ras Al Khaimah, i.e. in the UAE, are 664 million dirham, which, as your lordship suggests, is around 150 US dollars. So in relativity terms, we're not seeking to freeze a very substantial part of his personal assets.
Yes. Yes. Thank you for that.
So that's Dr. Shetty as the individual, and those are the assets we seek to freeze. In terms of the requirements of a worldwide freezing order, your lordship will be aware that broadly similar across the Commonwealth world at present, essentially a good arguable case on the merits of the underlying claim. And in this case, there's an overwhelming case of default by the primary debtors and by Mr. Dr. Shetty as guarantor, as the personal guarantor. There's something of a shadow of a defence that's been put up that the bank should have exercised its discretion in accordance with some obligation of good faith and should therefore have granted a remedy period to remedy the default. It's unclear how that would actually have assisted. But in any event, it's made very clear on the express terms of the finance arrangements that it's a discretion. We are entitled, the bank is entitled to give a remedy period if it so wishes. It's not something which the debtor or the personal guarantor can expect or demand. And then the second requirement is that the defendant has assets available to satisfy judgment. And obviously we rely on the net worth certificate, which we've just been looking at. Substantial assets are clearly disclosed in Dubai, not least those property assets. I should just say, on the subject of those property assets, they are some pretty extraordinary prestige property assets in terms of the first Burj Khalifa. He is said, Dr. Shetty said in the press, to have 2 floors of the Burj Khalifa, and similarly, World Trade Center residences, 8 residential units, properties on the Palm, a number of villas on the Palm. So very substantial property assets in Dubai, in onshore Dubai. And I should say, in terms of the order, we don't seek at this stage permission to enforce directly in onshore Dubai, but we do seek to bind Dr. Shetty with a personal liability under this order, such that if he were to dispose of assets onshore in Dubai, he would make himself liable to the contempt jurisdiction of this court, which obviously usually engages a reference to the Attorney General of Dubai. So the policing mechanism, if you like, is a Dubai-wide mechanism. So that's the second requirement. The third requirement is a risk of dissipation, where we'll have to look at some of the NMC health announcements, and I've trailed in summary the sort of issues in terms of related party trading, in terms of off-balance sheet debts, and in terms of the possibility of fraud. When you add to that the fact that Dr. Shetty has himself absconded to India, and the fact that he has presented various security checks which have been dishonoured, which in UAE
I just wonder if I could ask you about those.
Yeah.
Mr. Reid, I'm just a bit curious about those. I understand all you say about the announcements from the company in relation to the non-disclosure of arrangements with respect to the shares. But firstly, in relation to what you described as absconding to India, he asserts that he went to save the world to his dying brother, and there does seem to be evidence to the effect that his brother was dying and has in fact died. And so that would provide, at face value, that would provide some justification for the time at which he went. And I haven't checked the dates, but I expect that by the time he got there, it was probably too late to go back to Dubai or to Abu Dhabi, where he lives.
Well, my lord, we should
wouldn't that provide a possible innocent? Wouldn't that provide an innocent explanation for what he's doing there?
It provides a possible explanation. We know that he left. We believe he left in February, possibly early February.
Right.
We don't know when his brother may or may not have deceased. We do know that there was a flight ban in terms of returning to Dubai, which came into effect on the 26th of March. But right. we do say that, first of all, the timing seems more than coincidence. When one looks at the announcements being made by Topco in London, they are streaming out, the bad news is coming out in a big way in February. The checks, which are very significant in a very significant amounts, dishonoured in February. That would have had immediate implications in terms of the Dubai police and his ability to travel if they proceeded to investigate and put a travel ban. And as we understand. Sorry.
Just going back to the allegation of flight, I looked at a media publication, which is, of course, not the most reliable source of evidence, but I think that publication was in late March, and it referred to his brother having died the previous Saturday. And if that was right, then that would have a good reason for him being in India until late March, by which time the flight restrictions would have come in, assuming he stayed around for the funeral, however long that would have taken. I'm not saying, I'm just, because it's ex parte, I think I'm obliged to try and view things through the lens of the person who's not here. And it just seems to me that there may well be a plausible explanation for his presence in India. We don't know if there is, there isn't. I just don't know at this stage. In relation to the checks, if I could just move on to that while I'm interrupting you, your proposition is that there's a suspicion that he may have committed an offence against criminal law of Dubai by signing a cheque at a time we didn't have reasonable grounds to believe that there would be sufficient funds when the cheque was presented. Now that is on the basis that because he was a very significant part of the controlling mechanism of the group of companies, he must have known, just see if I've got this right, he must have known that the debts were much greater than had been disclosed, and therefore had no reasonable grounds to believe that the cheques would be met when presented. That's the argument, basically, is it?
My lord, that exactly. Just a short point of correction. It's UAE criminal law, so it's the UAE.
UAE criminal, yes, of course.
But to your lordship's point, exactly that. The debt on the balance sheet was around the $3 billion US. Yeah. What has in fact emerged is that the actual debt was nearer 6.6 billion US dollars. Yeah. So massive concealed debt.
When were the checks? I'm not sure there's a clear date on the checks, but I assume that the checks were provided around the time of the revised framework agreement in July of 2019. Is that when they were provided, or was it earlier?
My lord, we haven't been able to ascertain precisely when the cheques were provided by Dr. Shetty. The amounts suggest a total indebtedness of $25 million US, which means that they could, and again, I'm discharging my duty of full and frank disclosure, they could have been signed and provided in 2015 at the time of the second rescheduling.
At the time of the second supplemental agreement.
Precisely, but they could equally have been presented around the time of the amendment and restatement agreement, which is clearly 2019.
The other point I just want to put to you for your comment is that 25 million US is a lot of money in most contexts, but in the context of a group of this size, it was clearly trading on quite apparently successfully, despite the size of this debt. So in other words, 25 million in the context of a group of this size, I wonder if if you can draw the inference that knowledge that the debt was understated equates to knowledge that there would be insufficient funds available to cover the checks when presented. Do you have any submission?
Well, to that I would simply say that you have to have total confidence that at the time of presentation, these checks are going to be honoured. And it may be that at a particularly given moment in time, given revolving credit facilities, whatever else, that there may be some hope that they could. But you are making a representation that as and when it will be presented by the bank, there will be money available, and given the extent of the net debt, we say that is simply a representation he could not have made. And that appears to be broadly accepted by the Dubai police insofar as they have registered the charges and appear to be proceeding on the basis that there is a facial allegation that they need to investigate. But I don't wish to put it more strongly than that. We don't place significant reliance on absconding to India, we say it seems likely that what is really happening is that he has absconded, that he and his family, I should say, have absconded to India. And it seems likely that, as at the time he signed and presented and gave the checks, his representation that the checks would be honoured and the companies had the assets to honour those checks was a misrepresentation in bad faith. And indeed, that as a matter of UAE criminal law is almost an assumption where a check is dishonoured. And your Lordship may be aware that the police routinely investigate dishonoured checks on the assumption that there is likely to have been bad faith, and that. But we say further to that in this case, where one knows now the extent of the actual debt being carried by this group, and where one knows too, because it's been revealed as part of the investigation by the independent committee of the board, where one knows too that security checks in a total amount of around $100 million have been written. Given the scale of that debt and given the amount of the security checks, it's not just the amount of this debt, but one has other security checks which are clearly going to be drawn upon at a time of crisis when there is default in payment, and when these security checks are going to be being applied. We say there is a prima facie case of a misrepresentation in bad faith, which we say needs to be added to the tally in terms of the discreditable conduct by Dr. Shetty, which we say presents a risk of either frustration of enforcement or dissipation of assets.
Is there anything else you'd like to say, Mr. Reid?
Well, that's just my sort of broad instruction. I was proposing to then go to documents, my lord. If your lordship has any particular...
Mr. Reid, I don't think, to be frank, I don't think you need to. I've read all the documents. I understand your arguments. I don't think there's any need for you to go any further unless you feel that there are particular aspects of the documents that I may have missed.
Well, my lord, if I don't need to go further, then I won't.
All right. Well, yes, probably the most, Mr. Reid, you'll gather from what I've said, I've formed the view that I should make the order that you seek, and what I would propose to do is to give the reasons for that view, and then come back and talk to you about the precise detail of the order. I've got a few questions that I want to raise in relation to that. Is that a convenient course?
Of course.
Yes, all right. Well, I'll give the reasons for the view to which I've come now. There is before the court an application under Part 8 of the rules of the court. The applicant is the Credit Europa Bank in brackets Dubai Limited, which I shall describe as the bank. The respondent is Dr. Bavaguthu Raghuram Shetty, Dr. Shetty. By the application, the bank claims orders for a worldwide freezing injunction and for the provision of information by Dr. Shetty relating to his assets. The orders are sought pursuant to Part 25 of the rules of this court. The application is brought without notice to Dr. Shetty, which is quite usual in cases such as this. One of the conditions which must be established before interim relief of the kind sought can be granted is that there is a risk that unless restrained, the respondent will either dissipate or dispose of assets or put them beyond the reach of the enforcement powers of the court or other courts acting in aid of this court prior to judgment in the substantive proceedings to which this application is an adjunct. Such a risk, if it exists, may well be exacerbated by the provision of notice to a respondent when such an order is sought, which is why applications of this kind are usually heard without notice. I'm satisfied that there are good reasons within the meaning of that expression in Rule 25.8 for proceeding without notice to Dr. Shetty in this case, although he must, of course, be given notice as soon as practicable after this hearing. Proceeding in the absence of an interested party is quite exceptional as it contravenes fundamental principles of procedural fairness which underpin any system of justice worthy of that description. In this case, it's justified on a limited and strictly interim basis by the consideration to which I have referred, but it has at least three significant consequences which are relevant to my assessment of this application. Firstly, the evidence before the court has been adduced only by the bank, and there may well be other evidence which will be adduced by Dr. Shetty in due course, which may put the evidence presently before me in a very different light. It follows that any observations I make with respect to the facts are entirely provisional and have no enduring significance beyond this interim ex parte application. In particular, if and when Dr. Shetty participates in these proceedings, I will conduct them with a completely open mind, starting with a blank page, as it were, putting entirely out of my mind any provisional views which I might have formed for the limited purpose of this interim application. Secondly, as Dr. Shetty is unrepresented, it's incumbent on me as the court to look at all propositions of fact and law advanced by the bank sceptically and through the lens of Dr. Shetty's interests, and to actively seek out and consider anything which might weaken or diminish or rebut those propositions. To put it more bluntly and perhaps more colloquially, to the extent that there is any doubt, Dr. Shetty must be given the benefit of that doubt. Thirdly, there is an onus on the bank to make full disclosure to the court of any proposition of fact or law which might be adverse to its case. That duty has been expressly acknowledged and addressed and, in my view, discharged in both the skeleton argument and the affidavit in support. Before dealing with the substantive application before me, I must first assess whether there is a good arguable case that the court has jurisdiction to grant the relief sought. The bank asserts that there are at least three bases upon which the court has jurisdiction pursuant to Article 5A of Law No. 12 of 2004 in respect of judicial authority at the Dubai International Financial Centre, or DIFC, and which law I will call the Judicial Authority Law. First, Article 5A.2 provides that the court may hear and determine any civil or commercial claims where the parties agree in writing to file such claims in the court. In this case, the bank relies upon a series of agreements to which Dr. Shetty was a party. The first was the Framework Credit Agreement entered into in December 2013, as amended by two supplemental agreements, and I'll call those agreements collectively the FCA. And the second is a variation to that agreement made in July 2019, described as the Restated Framework Credit Agreement, and which I'll call the RFCCA. Returning to the FCA, Clause 17.1 of that agreement provides that the agreement is to be governed by and construed in accordance with the laws of the DIFC, and the same clause provides that any dispute arising under the agreement shall be brought exclusively before the courts in the DIFC, provided that that does not prevent the bank taking proceedings against the borrower or the guarantors, including Dr. Shetty, in any other court of competent jurisdiction. Somewhat curiously, Clause 18.1 of that agreement effectively repeats those provisions in virtually the same words. Turning then to the RFCA, Clause 9.1 of that agreement is in substantively the same terms as the clause of the FCA to which I have referred, and the amended FCA, which is attached to the RFCA, retains Clause 17.1 in essentially the same terms. So in summary, each of the two agreements upon which the bank relies effectively provide that this court is to have exclusive jurisdiction in relation to the resolution of any disputes arising under the agreements, but perhaps in a one-way sense, in a unilateral sense, in the sense that the bank is expressly given the capacity to sue either the borrower or the guarantor or guarantors elsewhere. Nevertheless, there is, I think, a strong argument that that provision confers jurisdiction upon the court under Article 5.2 of the Judicial Authority Law. The second basis for this court's jurisdiction arises under Section 5A1A of the Judicial Authority Law, which provides the court has jurisdiction in any claims to which a DIFC establishment is a party. Article 2 of the Judicial Authority Law defines a DIFC establishment to mean any entity licensed to carry on business within the DIFC. The bank is licensed to carry on banking business in the DIFC and so meets the description of a DIFC establishment, and as a party to these proceedings that provides an alternative source of jurisdiction. The third independent source of jurisdiction is Article 5A1C of the Judicial Authority Law, which confers jurisdiction on this court in respect of commercial claims arising out of any transaction wholly or partly performed within the DIFC. On the evidence before me, it's fair to infer that both the FCA and the RFCA were negotiated and documented by the bank within the DIFC. It's also relatively clear on the evidence that the funds were advanced by the bank pursuant to those agreements by actions taken by its branch within the DIFC, from which it is reasonable to conclude that the transactions which lie at the heart of the dispute between the parties were at least partly performed in the DIFC, and therefore there is a third alternative source of jurisdiction. So for those reasons, I am satisfied that there is a good arguable case to the effect that the court has jurisdiction to grant the relief sought in this application. That enables me to turn to the substantive application. The cases both in this court and elsewhere establish that 4 conditions must be satisfied before relief of the kind sought can be granted. Cases also show that the courts are very reluctant to permit any diminution in the standard of satisfaction which must be achieved to the effect that all 4 conditions are satisfied before relief is granted, given the exceptional effect of the relief sought and the ex parte character of the proceedings. The 4 conditions which must be established by the applicant to the satisfaction of the court are firstly that the applicant has a good arguable case, secondly that the respondent has assets or may have assets available to satisfy a judgment if such judgment is entered against him, thirdly that there is a real risk that the judgment may go unsatisfied in whole or in part if the order sought is not made, because the respondent may dissipate or dispose of the assets or otherwise put them beyond the reach of the enforcement powers of this or other courts acting in aid of this court. And the 4th condition is that in all the circumstances it's just and convenient for the order to be made. I'll deal with each of those conditions in turn, starting with the question of whether the bank has established a good arguable case. The bank's case, as I mentioned, relies upon the 2 agreements. Just briefly describing the nature of those agreements, starting with the CFA, the parties are New Medical Centre Trading LLC, a Dubai entity, NMC Healthcare LLC, which is an Abu Dhabi entity. The former, that is the Dubai entity, is a wholly owned subsidiary and trading arm of the latter, that is the Abu Dhabi entity. The Abu Dhabi entity is in turn wholly owned by NMC Health PLC, which is a company listed in the Stock Exchange of the United Kingdom, although it's presently suspended from trading in circumstances to which I will come. The trading arm, New Medical Centre Trading LLC, is a substantial private healthcare provider in the Emirates, and the group is a substantial healthcare provider in the Middle East and in other countries of the world, providing healthcare services to many millions of patients each year. The other party to the CFA is Dr. Shetty, who is the founder of the group and who was until a time in February of this year joint chair of the holding company, the listed company in the United Kingdom, and a substantial shareholder. The bank's case is that the evidence establishes an inference to the effect that each of the companies and the group as a whole were substantially under the control of Dr. Shetty. Under the CFA, the bank was to provide credit to New Medical Centre Trading in order that that company could pay suppliers of equipment which was to be used by it in the conduct of its healthcare business. The procedure contemplated under the CFA was that the borrower, that is NM Centre Trading, would give to the bank a disbursement letter indicating the identity of the supplier and the amount due to that supplier. The bank would then endorse the letter with the interest rate applicable to that advance and the repayment date. So in other words, the CFA set up a revolving credit facility under the initial form of the agreement. The facility was capped at $15 million US, although that cap was raised in the first supplemental agreement to $18 million, then in the second supplemental agreement to $25 million. Clause 13.1 of the CFA provides that if any payment is not made within one banking day of the day due, the entire amount due under the facility is immediately due and payable. The bank accepts that on the proper construction of the agreement, it has a discretion to extend or to provide a period of grace beyond that period of one banking day, but also submits that it has no obligation to exercise that discretion. There's no suggestion in the present case that the discretion has been exercised in favour of the borrower. NMC Healthcare and Dr. Shetty each guaranteed payment of all amounts due from NMC Trading to the bank under the CFA. The RFCA was executed in July of 2019. It varied some of the language and terms of the FCA, but in addition made two substantive changes. First, it altered the role of NMC Healthcare from guarantor of NMC Trading's debts to that of principal borrower, so that under the RFCA, NMC Healthcare became a principal borrower rather than a guarantor. Dr. Shetty remained a guarantor. The other substantive change achieved by the RFCA was the imposition of a requirement to the effect that a deposit of $3 million with the bank be provided by way of security for the facility the bank was providing. Turning now to the bank's case with respect to default, the bank asserts that as at the 4th of February 2020, $12,069,122.08 in US dollars was outstanding under the facility. Payments made by the bank to suppliers under disbursement letters sent in November and December 2019 fell due for payment on the 5th and 6th of February 2020. The payments due on those 2 days totalled $1,280,466.81, again in US dollars. None of those payments were made. The parties met on the 11th of February, and on the same day, payment of $499,970 US was made to the bank, and a payment in precisely the same amount was made a week later on the 18th of February. However, on the bank's case, no more payments had been made, and so the amounts due on the 5th and 6th of February haven't been paid in full. As I've noted, there's no suggestion and no evidence to suggest that the bank has exercised any discretion to extend the time for the purposes of making good any default, so that at least by the 7th of February and perhaps by the 6th of February, the entire amount due under the facility was repayable. In terms of the amount due under the facility, the two payments to which I've referred, being the payments made on the 11th and the 18th of February, total just under $1 million US dollars. And after the default continued for a time, the bank exercised its security over the $3 million US dollar deposit that it held, thus reducing the amount outstanding by just under $4 million. The balance due after the reductions through those means, and indeed the balance due as of the date of this application, appears on the bank's case to be $8,018,298.89, again in US dollars. Interest is accruing on that amount at the rate of $2,607.09 US per day. Also under the facility agreements, the bank is entitled to recover its costs arising from default. Those costs are estimated at $358,939.06 US. The bank seeks in this application an order freezing assets in order to ensure that assets to the value of its claim are retained, the total being sought being the value of $8,377,237.95 US. That figure is the combination of the balance of principal and the estimate of costs, and it doesn't include any allowance for accruing interest. Returning to the narrative, letters of demand were sent to each of the principal borrowers and Dr. Shetty as guarantor on the 17th of February. Apart from the payment that was made on the 18th of February to which I have referred, no further payments have been made either by the borrowers or by Dr. Shetty as guarantor. On those facts, I emphasise provisionally, and on those facts, which are based only on the evidence adduced by the bank, I conclude that the bank has a good arguable case against Dr. Shetty in respect of his liability under the guarantee. Given the strength of that case, it's unnecessary to analyse in any detail the cases that delve into the sometimes interesting question of precisely what degree of strength of case must be established to justify an order of this kind. Whatever criterion is adopted, I'm satisfied that in this case, the necessary condition of a good arguable case has been made out. The second condition that must be established is that there are assets which would be available to satisfy a judgment if a judgment is entered. The bank submits that Dr. Shetty is a high net worth person and relies upon a certificate which he gave to the bank in June 2018 certificate endorsed by his accountants, certifying his net worth at a little over 8 billion dirham, which would equate to a little over $2 billion US. There were significant assets held, according to that certificate, in listed shares, bank deposits, property, and a motor vehicle. In relation to the current value of those assets, there must be some doubt with respect to the value of the listed shares, given the circumstances of the companies with which Dr. Shetty was involved and to which I will shortly refer. But even leaving those shares to one side, the value of the property said to be owned by Dr. Shetty is itself very substantial and well in excess of, by a factor of many times, well in excess of the amount to which the bank is currently seeking an order to ensure that there are assets available to satisfy the judgment it might obtain. There's no evidence that Dr. Shetty holds any assets within the DIFC, that is to say within the jurisdiction of this court, but the case has established that the existence of assets within the jurisdiction is not a requirement for the exercise of extra territorial jurisdiction. And in this case, I note again that the parties decided and appear to have agreed that this court would have exclusive jurisdiction, and this court seems therefore an appropriate vehicle for the resolution of this issue, notwithstanding the fact that on the evidence there don't appear to be any assets within the jurisdiction of this court. The third condition which must be satisfied by the bank before it can obtain the relief it seeks is that there is a risk that assets will be dissipated or disposed of or put beyond the reach of this court or other courts acting in aid of this court. The bank's case in that regard is that there is evidence which raises a good arguable case that Dr. Shetty has been guilty of what is described as commercially discreditable conduct, from which an inference of risk can be drawn. That conduct is said to arise from the following circumstances. Until at least the latter part of last year, the NMC Group had the appearance of success. It was listed on the stock exchange in the United Kingdom, was regularly reporting substantial profits, and its balance sheet showed that its assets were well in excess of its liabilities, which were publicly disclosed at somewhere around the mark of $3 billion. There was a report published by an organisation known as Muddy Waters in December, which cast doubt upon the accuracy of the published accounts of the group, and which also suggested there are other aspects of the group's activities that gave rise to reasonable grounds for suspicion. The board of the parent entity initially refuted those allegations in their entirety, but undertook investigations nonetheless. Those investigations have given rise to a series of disclosures and ultimately to resignation or departure of almost all of the board and the senior executive team in the group. Amongst the disclosures that have been made is the extent of the debt was $6.6 billion rather than the amount of around $3 billion previously disclosed. The company's been suspended from trading on the UK exchange since mid-February. As I say, all senior personnel have left. Corporate restructure teams have been engaged to try and save the trading enterprise, and investigations with respect to the conduct of the directors and executive members of the company are continuing. The specific allegations made against Dr. Shetty, or perhaps more correctly, the matters that are said to justify an inference of discreditable conduct giving rise to the risk of dissipation of assets or some other attempt to put them beyond the reach of the court, includes the following. Firstly, it's said that there is evidence to suggest that Dr. Shetty failed to fully disclose the precise extent of his shareholding in the listed company by reason of a number of matters, including the fact that he held shares apparently in his name when they were beneficially held by others, and secondly, that he'd pledged his own shares, shares apparently held directly by him, and also shares which he held beneficially on behalf of others, as security for borrowings, none of which was disclosed. disclosed and which created the impression that he had a greater interest in the company than was in fact the case. It said that when account is taken of the true circumstances, particularly after the banks to which the shares were pledged as security have exercised those securities and taken the shares, the net shareholding of Dr. Shetty and other substantial shareholders in the company has fallen below the figure of 30%, which triggers the operation of some change of control provisions in financing arrangements into which the company has entered. It's also said that an inference of discreditable conduct can be drawn from the fact that Dr. Shetty was instrumental in providing the bank with 3 cheques, one from NMC Trading, one from NMC Healthcare, and a cheque from him personally, each in the amount of dirham roughly equivalent to $25 million US and undated. The evidence doesn't establish when those cheques were provided to the bank, but when they were dated in February of this year and presented, all cheques were dishonored. It said that there's an inference arising from that to the effect that Dr. Shetty did not have the requisite belief that the cheques would be honoured and when presented, and therefore has breached the criminal law of the UAE. In a circumstance in which, as I've already mentioned, in my view, the benefit of any doubt must be given to Dr. Shetty, that he's not here to answer the propositions being put against him. I'm not presently satisfied that there is evidence from which I could infer that he lacked the requisite belief that those cheques would be honoured when presented, given the absence of any evidence as to the date upon which those cheques were provided to the bank or as to the circumstances of the company at the time those cheques were provided. Another matter upon which the bank relies in support of the proposition that I should infer that Dr. Shetty has been guilty of, or at least there is a case to the effect that Dr. Shetty has committed commercially discreditable conduct, is the non-disclosure of the true extent of NMC's debts. It said that Dr. Shetty's position within the group was of such a nature that it can be inferred and should be inferred that he must have been aware that the amount of the group's debts were very substantially understated in the published accounts of the company. It's also said that there is evidence to suggest that Dr. Shetty arranged for NMC to give security for the payment to suppliers who were supplying goods and services to him personally or to companies in which he had an interest. That is, that there were related party transactions going on for his benefit which weren't disclosed. Another matter that the bank prays in aid is the fact that Dr. Shetty went to India, and I note in this context that Dr. Shetty is and remains an Indian national, with his family at about the time public disclosure of some of the problems with the group were surfacing, and has remained in India and hasn't returned to his normal residence in Abu Dhabi. The bank characterised this as absconding or as flight. I'm again in the context in which Dr. Shetty is not here to provide an alternative explanation. I'm not presently persuaded that I should put that characterisation upon his travel and movements. There is evidence to the effect that he returned to India in order to spend time with his brother, who was dying and has since died. And it is at least a possibility that by the time he discharged that family obligation, it was too late to return to Abu Dhabi because of the travel restrictions that have accompanied the coronavirus. So again, in a circumstance in which, in my view, the benefit of any doubt should be given to Dr. Shetty, I'm not prepared presently to draw an inference adverse to him from his return to India and the fact that he's remaining in India. Reference is also made and reliance is also placed by the bank upon conduct in a related, or not related group, but another substantial corporate group in which Dr. Shetty has a substantive interest. That is the group known as Finabler, spelled Finabler. It's said that within that group there is evidence again of similar conduct of the kind that has occurred within the NMC group, namely non-disclosure of the true shareholding of Dr. Shetty within that group, and the existence of related party transactions to the benefit of Dr. Shetty not disclosed to corporate entities or to the public. The test that I must apply to these allegations is whether they establish a good arguable case to the effect that the respondent engaged in discreditable conduct, such as to give rise to a sufficient risk to justify relief. Provisionally, and I emphasise that all the views I express in these reasons are provisionally aiming at that view, the material to which I have referred and which I do take into account, leaving aside the checks and the movement to India, are in combination sufficient, in my view, to give rise to a good arguable case that impugns the conduct of Dr. Shetty to the point that there is an appreciable risk that he may take steps, unless restrained, to remove assets beyond, so that they are no longer available to the bank should it obtain judgment against him. It's clear that the commercial calamities of the groups with which he is involved must have resulted in a very substantial erosion in his wealth. In that context, I would infer that he has every incentive to try and protect whatever assets remain to him. And so if the matters that have been alleged by the bank are established in proceedings in due course, they would support an inference that Dr. Shetty has propensity to bend legal requirements in order to give priority to personal advantage, and that sustains the conclusion the condition relating to the risk of dissipation or disposal of assets has been satisfied. The fourth condition which must be established by the bank is that the relief terms sought is just and convenient. That requires me to take into account the effect of the relief sought on Dr. Shetty. On the evidence, the relief sought, which effectively restrains dealing in assets up to the value of the bank's claim, that is to say a little under $8.5 million US dollars, would not appear to impose a significant hardship upon Dr. Shetty. As I've noted, in the middle of 2018, he asserted to the bank that his net worth was in the vicinity of $2 billion US dollars. I've also noted that there's reason to suspect that that net worth may be significantly less as a result of the calamitous circumstances of the two large commercial groups with which he is involved. But nevertheless, the property disclosed in the middle of 2018 is of itself of extraordinary value, that is to say a value many times greater than the amount with respect to which the bank seeks to restrain Dr. Shetty from dealing. On the evidence before me, there's no reason not to grant the relief sought in those circumstances. The bank also seeks an order to the effect that Dr. Shetty provide information with respect to the extent and location of his assets. Given the evidence with respect to the diverse nature of Dr. Shetty's assets and their location in different jurisdictions, it is, I think, appropriate that that order be made so that the bank can be given the information with respect to those assets. Of course, the relief sought will be conditioned upon the bank doing undertakings to pay to Dr. Shetty and to any third parties any recompense that may be appropriate if they suffer any loss by reason of this order not ultimately being justified. There'll also be a short return date for a further hearing in order to ascertain whether maintenance of the order is justified, and I propose to give Dr. Shetty liberty to apply to vary or set aside the order on short notice, and also to direct that the substantive proceedings against Dr. Shetty and the parties said to be principally liable for any debt must be commenced quickly. So on those conditions and for those reasons, I'm disposed to make the orders sought. But I would now seek to engage counsel in relation to precise terms of those orders. Mr. Reid, if you've got the order there, just looking through what we need to do, I think, is obviously you want to get this order out as quickly as possible. If we can go through and effectively settle the terms of the order now, and if your solicitors could then provide it to the court, they'll run it past me and then the court can issue it, and that should enable the thing to proceed. if you've just got if you go to order 1.1, obviously my name needs to be inserted on the second line there. So made on the 10th of April by Justice Martin. Order 1.3 for the hearing. Obviously, Dr. Shetty's in India, but I see later in the order it's proposed to be served by email. There is reason to believe that he does receive information given to him by email, is there?
My understanding is yes, he has communicated. We have a reliable email address for him.
Good.
Yes, I'm just...
In terms of return date, of course, Friday, as I'm sure you're aware, Friday and Saturday, the weekend in Dubai is Friday and Saturday. So I was going to suggest that around a week, but perhaps either Sunday the 19th of April or Monday the 20th of April for the next return date. Do you have any...
I think, my Lord, I'm obliged to take your Lordship to RDC 25.12, if your Lordship has it to hand.
Right, and what does that? Can you just help me?
I can read it out.
What does that provide?
Subrule 4 says, where a party makes an urgent application, and then subrule 5, when acting on the procedure set out in this part, the court shall set a return date for the hearing of the application before a judge sitting alone, which shall not be later than 3 days from the date upon which the interim order is issued. So there's an extremely strict requirement in the rules that it be within three working days. Obviously, there's an expectation the parties will then agree to postpone it, but that's where we are in terms of procedural rules. And given the
three. Sorry.
I should just say, so I'm not sure in terms of public holidays, but it seemed to me that took us to the 14th of April.
Yes. Well, I don't think there are any public holidays in Dubai at the moment. So that would mean today is not a working day. So the 3 working days would be Sunday, Monday, Tuesday, which would, yes, I think that would be the 14th. So let me just look at my calendar. Yes, I think that means we need to relist it on the 14th. Perhaps at the same time, is that? I mean, I expect it'll be adjourned. I would hope it'll be adjourned. But is this time convenient to you and your instructors, Mr. Reid?
We're all in lockdown, my lord. So
yes, all right. All right. Well, let's adjourn the matter then until 1 p.m. on Tuesday, 1 p.m. in Dubai on Tuesday, the 14th of April. And if the parties can agree an adjournment to another date, I'd be very willing to allow that to occur. If there's no appearance by Dr. Shetty on the 14th, then I'll stand it over for a rather longer period, I think.
My lord, yes.
All right, so then on 1.3 we'll insert at 1 p.m. on Tuesday the 14th of April. Moving on, Mr. Reid, to paragraph 3.1, given the ambit of Dr. Shetty's assets, 3 working days seems a bit tight to me, and I assume he's got a few other things on his mind at the moment. I was going to suggest we might make that 5 working days in 3.1.
I have no objection. I'll just check for instructions on it, but I can see it.
And then there'd be a corresponding...
Well, yes, that's fine, no objection.
And there'd be a corresponding change in paragraph 3.3. We'd add 2 days to that as well, so we'd make that 9 working days. So it's 5 working days for the information, 9 working days for the affidavit. Then, in relation to order 4.1, 5,000 per week for a man of Dr. Shetty's station in life seems to me to be a bit light. I was going to suggest perhaps 7 or 8,000 US, perhaps 7,000 US.
I see no objection to that, and that seems okay.
Yeah. And then the second sentence troubles me in 4.1, which provides before spending any money, the respondent must tell the applicant's legal representatives where the money is to come from. Now that would mean if he went down the street to buy some food or to take a taxi, before doing so, he'd have to tell your instructors which wallet he was taking the money from. I just wonder how practical that is.
Yes, I mean,
given the scale, the apparent scale of his assets, I just wonder if that's necessary.
Yeah, it comes from the standard form. I should say it's in square brackets, so it's optional.
Yes. Well, I'd prefer, unless you want to argue against it, I'd like to take that second sentence out. And so the first sentence would be US $7,000 per week on living expenses reasonable sums. I mean, the reality is, if his assets remain of the magnitude that we infer they do, his living expenses will be available from assets that are well above the amount that you're seeking to restrain.
Yes, and if he's given disclosure of all his assets, and if he's restricted in his spending to $5,000 a week, that imposes the necessary discipline.
Yes. Well, I was going to suggest 7,000 a week.
Yeah, sorry, 7,000. Yes.
4.1. So can we make that 7,000?
We've made that 7,000. Then yes, that's...
Yes, and then in 9.5, I'm sorry. I want to include a provision for liberty to apply, which we could probably make a new order 9, and it would be in the terms that the respondent has liberty to apply to set aside or vary this order on 24 hours notice to the applicant.
My only reservation about that, and my suspicion as to why that's very uncommon in this sort of order to have a liberty to apply, is that given that we're going to be back in 3 days, a liberty to apply on 24 hours notice doesn't really affect much difference. Yes,
I'm persuaded, Mr. Reid, forget about that. If we go to 9.5, again, this is the standard form, I know, but just 9.5b, I would prefer to put any person who is subject to the jurisdiction, but these requirements are, as I read them, cumulative.
Yes.
In 9.5b, so it should be any person subject to the jurisdiction of this court, and I prefer to put "and" in after that.
Yes.
And has been given notice of this order and his residence, and then again within the jurisdiction of the court, and is able to prevent. So if we just put a couple of "ands" in there, that doesn't leave any room for argument.
Implicit, but yes.
Yep. And then moving then to the undertakings to be given by your client, item 2, the commencement of the substantive proceedings. Do you have a feel for when obviously I would like them to be commenced as soon as possible. In practical terms, when do you think your instructors might be in a position to launch them?
Well, we should be in a position, I would have thought, by Sunday or Monday. I mean, it's just the claim form. It's not the particulars. So it's literally just, the claimant claims this amount by reference to this agreement.
Well, could we make it, I was going to suggest just to give you a bit of leeway, item 2 could read as soon as practicable and not later than Sunday the 19th of April.
There is some English case law which suggests as soon as practical is a matter of hours rather than days. So I wonder in those circumstances if we just say not later than Sunday 4 p.m. on Sunday the 19th of April.
Not later than 4 p.m. and not later than as soon as practicable and not later than 4 p.m. on Sunday the 19th of April.
Well, I wonder whether we could take out as soon as practical. We've got a firm time limit, and it just seems to me that as soon as practical just adds an issue.
Yes.
So
let's do that up. I mean, it's not as if the nature of the claim is going to come as a surprise to anybody. So I just say take out as soon as practical. Just put not later than Sunday 19th, 4 p.m. on Sunday 19th of April. The applicant will issue and serve Part 7 or Part 8 of the claim. Now, just moving on to item 3, that is the documents you're going to serve. You may not be able to serve an application notice for continuation of the order because you may not be able to file it at the court because it's shut today and tomorrow. Yes. So I was going to suggest we might put in there an application notice or draft application notice for continuation of the order.
Yes, that would be very helpful.
Item the end of 3. I'd also like to impose an obligation upon you to serve transcript, and so I was going to suggest an additional order in terms as soon as practicable after the transcript of the hearing at which this order was granted is available. The applicant will serve a copy of that transcript on the respondent in the manner described above, that is by email to the 2 addresses shown there.
My Lord, That would be helpful. I understand. I mean, this session is this hearing, sorry, is being recorded.
Yes, and I understand it will be transcribed. So as soon as the transcription is available, I think that should go to the respondent.
Yes, if the order could refer specifically to the transcription. There's been a lot of case law in the UK about handwritten transcripts and the extent to which they're full or to the extent to which they're misleading, because they are just an attempt to capture all that is said. So if we could do it by reference to the transcript, that would be very helpful. Yes.
So as soon as what I've written down here, as soon as practicable after the transcript of the hearing at which this order was granted is available, the applicant will serve a copy of that transcript on the respondent in the manner described.
My only right just now, my lord, is I understand there was at least one very minor factual error in referring to trading, or one of the Abu Dhabi company when it was the Dubai company.
I see.
And so my sisters would like the opportunity to propose some amends just to correct any very minor factual errors that may make it onto the transcript in its first draft.
So, well, perhaps after the revised transcript is available.
My lord, yes.
Yes. Otherwise, I'm happy with the orders in the terms proposed. So if your solicitors could send a version of that order to the registry, they will endeavour to provide it to you in a form in which it can be served as soon as possible.
My lord, we'll do that. We'll do that today, and indeed as soon as possible.
Yes. Good. Is there anything else?
My lord, no, I don't think so. In terms of full and frank disclosure, that is, your lordship referred to the affidavit, the skeleton. There's a section in the skeleton which sets out full and frank disclosure, and I think your lordship referred in the judgment in the reasons to the fact that your lordship was persuaded that that duty had been discharged. So
yes,
there was some wondering that whether I needed to sort of go through a list, but it's there in the skeleton.
No, I've read all the disclosures, and I'm satisfied that you've drawn my attention to any matter that could be contrary to your case, and I've taken that into account.
I'm grateful, my lord.
Good.
Well, my lord,
all right. Well, as I say, if something can be done to avoid the inconvenience of having to meet next Tuesday, I'd be grateful for that. But otherwise, we'll reconvene, probably, I imagine, quite briefly next Tuesday, and then stand the matter over again until sometime when Dr. Shetty has got a realistic opportunity to respond to it if he chooses to do so.
My lord, yes.
All right. Thank you very much, everybody, for your time.
My lord, we're very grateful for your hearing.
It's a pleasure. Thank you. Goodbye.
Thank you.